Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goway, joined again today by Mira Prisco, an associate here at Thomas Fisher and Edwards in Greenville, South Carolina. Mira, thanks for joining me today.
Thank you for having me. I'm excited to be back.
Yeah, so today we are going to talk about healthcare powers of attorney, which is in many cases one of the most important parts of an estate plan that often gets overlooked or kind of pushed to the back burner. We want to talk about our fancy tax planning techniques and where all the assets go when someone dies, but a healthcare power of attorney is something that can be incredibly important for a client. And so why don't you start off by telling us what is a healthcare power of attorney and why should practically any adult have one, regardless of what assets they have or how old they are or anything?
Right. So a healthcare power of attorney is a legal document where a person, the principal, names an agent to make healthcare decisions for them in the event that they are not able to make them for themselves. And it's an important document because healthcare emergencies are unexpected oftentimes, and you want to make sure that you have designated a clear person to help make decisions for you. Mm-hmm. There's no telling when an accident could happen. And it doesn't really matter what your assets are, what age of adult you are. You could have an accident or some kind of healthcare emergency, whether you're 25 or 95. Mm-hmm. And so it's an important document to have for all adults.
Yeah, and it's particularly important because we want to avoid what would happen if you don't have one. And so can you briefly go through what's the alternative to a healthcare power of attorney if you do not take the time to have this document prepared?
Right. So the state has a list of people that have priority essentially in making decisions for you. However, not everyone may want the people in that list to be making decisions for you. It's sort of a next of kin list. Mm-hmm. However, you may not want your husband or your adult children to be making these decisions, not because you don't love them, but maybe they're just not the best person to be making healthcare decisions for you. And so you really want to choose who you want before the state's list sort of tells you who it would be.
Yeah, not only that, but also just to get that state's list implemented, there may be need for a court action. You may have to go get a guardian appointed or something. And so it's a lot easier to just fill out the state form, which we'll talk about here in a moment. Talk with your attorney about it, get that filled out, get it signed properly so that everything is very clean and consistent with your desires, and that there's no court involvement. And as you mentioned, you're not just going down the list of who the state guesses based on just their idea of who is going to be close to you, who you would want to be named in that role. And so, as I mentioned there briefly, South Carolina has a statutory form, and we'll focus on South Carolina law today for purposes of the podcast. What information is required in that statutory form when you name agents as your healthcare power of attorney agent?
Sure. So you're going to first name your primary agent. So you'll have sort of a first choice, and it will have their contact information, so their full name, their address, their phone number, and then you'll have the successor agents also listed. And it's important to have up-to-date information so that those people can be contacted if they need to be in the event of healthcare decisions needing to be made.
Yeah, and a question I often get from my clients is, how many individuals should they name? Should they just name that first one? Should they have one backup, two?
I would always recommend having at least one backup, but I think it's also important to look at your agents, right? How old are your agents? Mm-hmm. Maybe if you have a lot of agents around the same age as you, maybe naming two backups in addition would be the right choice. So just look at who you're naming, the ages, the circumstances around them, but at least one backup I would recommend.
Yeah, certainly facts and circumstances related. I've got a lot of young clients who, maybe they want to name their parents because maybe they're unmarried, but Their parents are probably
Right.
going to have health issues before they do, so it's probably good to name someone younger. Sometimes you'll have a husband and wife where they want to name each other. Well, if they got in a car accident, there's a decent chance that they'd be in an accident together, and so you want to at least name a backup to that. So thinking through
Right.
some of that can be helpful, whereas if it's an older person and they're naming their two children, they might not necessarily need a third one because one of their two children will likely be available.
Sure. And I think that people have the hardest time choosing an agent when they don't have adult children.
Mm-hmm.
So if it's just a married couple with no children, they often struggle with who will be the backup agents. And so, again, looking at the ages, the facts and circumstances of the people around you, naming friends that are the exact same age as you
Right.
could be difficult.
Another question I often get from clients is who should they choose as their agent? Like, do they need to, maybe they've got a child who's a nurse and they're like, okay, I want to name this child. But outside of, kind of the obvious situations like that where they have someone who's a medical professional, how is it best to pick a person? Does it need to be someone with any sort of expertise, or how do you advise clients on that?
I don't think it needs to be anybody with, some sort of medical background or expertise. I would say the number one thing to look at, are they trustworthy? Do you trust them to carry out your intentions and what you would want?
Mm-hmm.
We kind of often say in meetings, it's both a benefit and a burden in choosing an agent. You are sort of enlisting them with some, what could be potentially hard emotional decisions. And so really choosing somebody who can handle that responsibility in a way that you would want.
Mm-hmm. Yeah, I agree. Someone that's trustworthy, someone that's going to be there, and there's going to be a doctor or a nurse or someone who is going to be there to provide their expertise. They just need to be able to converse with that professional and take the advice, and then, as you mentioned, understand what you would want and try to apply that for you. And so, obviously, as we talk about that, them doing what you would want, it's because you're not able to make those decisions yourself. So can you tell me, when does the healthcare power of attorney become effective, and what sort of authority does that agent then have when it becomes effective?
Sure. So I think I mentioned earlier, in the event you are not able to make decisions for yourself, so in a state of incapacity, the agent will be given sort of broad medical authority in the sense of whether or not to, choosing a doctor, transferring you between hospitals, if you need to be checked into a nursing facility of some sort. In addition to the things that you get to kind of designate. So there's organ donation, end of life treatment, and then nutrition and hydration.
Yeah, and so and we'll talk about that. So as you mentioned, it's broad authority. I mean,
Yeah.
treatment options, what type of medicine, basically the decisions that you would get to make for yourself. But there is an ability for the principal, the person who ultimately becomes incapacitated, to state in advance what we call an advance directive, state in advance what they want certain situations, how they want certain situations to be handled.
Right.
And so let's go through those situations which you just listed. So the first is organ donation.
So we typically tell people that just like you're able to designate on your license, you can designate whether or not you want to have organ donation, if you want your organs to be donated. But we tell people, try to be consistent with what's on your license, just because you don't want any discrepancy there. And people really go back and forth. I would say 50% of our clients say they want to be organ donors and 50% say they don't.
Yep.
And so that's typically an easy decision to be made for most clients.
Yeah, and it does grant the discretion to the agent if they choose that, so that the agent can then kind of make the final decision, but it does allow some flexibility there. The next item that is part of this advanced directive part of the healthcare power of attorney is the decision on how to handle life-sustaining treatment. So when does that apply, and what options does a principal have in that scenario?
So that applies when the principal is in a state of permanent unconsciousness or has a terminable illness. And so there are 3 options that the principal has that they can make, obviously, ahead of time. And the first option is to prolong what we would say maximum treatment to continue life. So even if they're in a state of permanent unconsciousness, they want maximum treatment.
Yes, effectively life support.
Life support, yes. Another option for that is that they want the treatment withheld. They don't want to be artificially prolonged in any way. And then the last option would be to designate, the agent you've had. They get discretion in choosing between those two options that I previously just said.
Right.
And so those are the three options. And really we have sort of a mixture of what clients want. Some people say they don't want their agent to have that burden. So they don't want treatment. Some say, no, I'm choosing this person. I want them to have the discretion.
That's right. It's sort of the benefit of choice and the burden of choice.
Yes.
In that this agent is the person that they've chosen. They think that they're the right person to make decisions. So they often will look at it as, well, they can weigh all the facts and circumstances and decide whether or not to use life support. But at the same time, and I see it a lot, you mentioned earlier when they're adult children, I do see situations where it's their adult child and they're like, I don't want to put that burden on them, so I'm going to go ahead and make the decision that I don't want that treatment is something that I will see often in those scenarios. And the third option that they get to choose on the form deals with nutrition and hydration, which is essentially a feeding tube in sort of the same situation as what we were talking about with the life-sustaining treatment. And how does that decision work?
We typically tell people to be consistent with what they chose for the life-sustaining treatment, because it would not really make sense if you wanted the agent to choose whether or not to continue life-sustaining treatment, but then say, absolutely not, I don't want nutrition or hydration. Those sort of conflict with one another. So the options are the same. Maximum treatment is how I like to explain it. Withhold if you're going to be in a state of permanent unconsciousness or terminal illness, or the agent has discretion. But people often choose a consistent option with the life-sustaining treatment.
Yeah, I think the vast majority will pick the same option. I have had some clients who, even if they choose to grant discretion on the life-sustaining treatment, they'll withhold or withdraw on the nutrition and hydration just because they're really worried about a feeding tube being invasive and painful. And they've heard stories, I guess, on that. And of course, it's their decision. So I will see that sometimes, but mostly it's going to be the same decision on that.
And on the flip side of that, I had a professor in law school who said he's very concerned about being thirsty, and that he chose in his documents to have nutrition and hydration, even though he did not opt for life-sustaining treatment. I always think of that when people are making their choices.
Yeah, everyone can always, make their own decisions, but I do agree with you that typically, and it makes sense in my mind, that you would make the same choice on that. And so another thing that I often get questions about when I talk to clients about their healthcare power of attorney is a living will, or which in South Carolina is known as a declaration of a desire for natural death. And how does a healthcare power of attorney differ from a living will, and how are they related?
Sure. So a healthcare power of attorney is broader. So a living will has those decisions we just talked about, the life-sustaining treatment. But a healthcare power of attorney designates your agent to make the other healthcare decisions we talked about: medication, choosing a doctor, choosing a hospital, all those things. And so really, the healthcare power of attorney includes what a living will does, but is broader. And that's why you do not see us doing both a living will and a healthcare power of attorney, because they overlap so much.
Right. And the healthcare power of attorney I look at as being a better overall document because it's broader. But people do have this concept of a living will in mind as being something that they need because they often get asked about it. I think it's a common question. Just when I personally go to doctor's appointments, they say, do you have a living will? And so part of that is because living wills were created by statute before healthcare powers of attorney were, and so they've been around for longer. But it is an important consideration for us to talk through with our clients, because there can be complications when they have both documents, correct?
Right.
And how can that work?
So living wills sort of trump healthcare power of attorneys. So if you've made decisions that conflict with your healthcare power of attorney within your living will, your healthcare power of attorney will not rule your living will.
Right.
So you will need to revoke your living will, and that way just one document, your healthcare power of attorney, is sort of the decision-making document. You wouldn't want to have any conflicting interest there.
Yeah. So for the listeners out there who maybe have both of these documents, it probably is good to take a look at both of those and make sure that you've made consistent decisions, because otherwise it can be problematic. If you have both and the decisions are consistent, then typically that is fine. But it is something that we always try to look at. We ask our clients if they have both. I typically do not prepare a living will for my clients unless they already have one. But if they do already have one and we're signing a new healthcare power of attorney, I'll typically sign a new living will at the same time to make sure that their decisions are consistent.
Right.
And if they're not going to make decisions on a living will that would have been consistent with the healthcare power of attorney, I may just revoke the living will as you suggested.
Sure.
And so just to kind of wrap up today, healthcare power of attorney is a very important document and something that our listeners should really think through carefully and make sure that they have and make sure that it's consistent with their desires. What are the common mistakes that you see related to healthcare powers of attorney, and how can our listeners avoid these mistakes?
Sure. So one thing I see is in conferences, if it's a couple, they'll say, well, what are you choosing to their spouse? And I always try to say, you don't have to choose the same thing. Choose what you want, not what somebody else would choose.
Right.
The other thing is not telling your agents that you have these documents and not having these documents anywhere that can be found. So these documents are only effective, the healthcare power of attorney is only effective if you bring it into a major surgery or you upload it to MyChart, which you can do. And if your agents don't know they exist, then they won't know what your choices are and what your wishes are.
Yeah, I think that's a very important point, is making sure that your agents know, making sure that it's accessible. If it's locked up in the safe with your will and your trust, then it's not very helpful. Whereas when we sign with our clients, we typically make several copies and tell them explicitly, put this in the hands of the people that may need it, upload it onto MyChart, put it on file with your doctor, so that you can make sure that they actually have access to this document. And also actually talking with those individuals, because yes, you make some decisions on the form, but you may have very specific concerns over health or specific thoughts about how you want your health managed. And so talking with those individuals about your desires so that they can best carry those out.
Yeah, for sure.
And so this is a very important topic, and thanks for coming on today to talk about it, Mira. I thought that this would be very helpful for listeners to hear.
Yes, thank you for having me.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.